Jane, are you there?
I'm here.
All right. Good morning, everybody. My name is Eric Yen. I'm the Director of Marketing for Shield HealthCare. Welcome to our webinar titled End of Life Decisions, a Planning Checklist. Attendees will be in a listen-only mode. If you have a question, please type it in the chat box to the right-hand side of your screen. At the end of the presentation, we will open it up for questions. This webinar is being recorded, so if you missed any portion of this webinar, you can go back to our community site to listen to the recording. At this time, I'd like to pass the presentation over to Jane McNamara. Jane was admitted to the California Bar in 1991. She's an accredited attorney with the Veterans Administration, a board member of Life Care Planning Law Firms Association, and is a member of numerous organizations dealing with the rights of seniors. Jane and her dedicated staff assist veterans, seniors, and their families with complex issues related to aging, illness, incapacity, asset protection from the high cost of long-term care, and public benefit eligibility. At this time, I'd like to pass the presentation over to Jane.
Thank you. Good morning, and welcome to the webinar. Although I'm a California elder law attorney, we're going to be talking about things that affect everybody on a national level. And so the things we're talking about affect every state. And I'm really happy that you're here. I want to congratulate you for being part of this, because part of a little bit of my frustration as an elder law attorney is I feel very bad when family members come in and their loved ones have done no planning at all. They haven't gone through this checklist. They haven't put their wishes in writing, and the poor family members are left holding the bag. And it's incredible heartache. It takes an amazing amount of time for them. They second guess themselves, and they have to live with that. You know, did I do the right thing for the rest of their lives? So it's really important that each and every one of you is here today, and I'm happy that you're here. So hopefully by the end of this webinar, you'll know exactly what decisions you need to make, how to legalize those decisions so people will carry those wishes out in a legal manner. So let's get started. So a couple of things, food for thought that I want to go over. You know, people don't tend to think about their own death. They just don't like that. I can't blame them at all. I don't like to do that either. But you know, whether you're young or old, you know, I get people who are 88 years old, they're in terrible health, they're coming in wheelchairs, and they just think they're never going to die. Well, you know what? Guess what? It's right around the corner. But then you get the people who are, you know, 53 years old and they have a brain aneurysm. My husband was run over by a tractor last year. Oh my goodness, he almost died. He was in the ICU for 5 weeks. I mean, yeah, for 5 weeks. Incredible stuff that we never think is going to happen to us. So even though we don't like to talk about it, we all need to plan. If you don't plan, people have to guess. And in the worst case scenario, a loved one has to actually go to court and has to get what we call in California a conservatorship. Or in other states, often it's called a guardianship, because the court has to give somebody the power to make decisions for you. So we really want everybody to make their own decisions in advance and make them legal. So what kind of decisions are we talking about? Well, the first one is healthcare decisions. How do you feel about your own healthcare? What do you want? What don't you want? This needs to be documented. So we'll talk about that. We're also going to talk about financial management and incapacity. Incapacity is like my husband who got run over by the tractor. He's in ICU. He's young, but he can't make decisions. He was heavily medicated. To the person who does have dementia and can't make decisions. So financial management, we need to talk about power of attorneys, things like that. The third thing we need to think about in our checklist is how are you pass your assets on to your loved ones. These are inheritance issues, transfers on death. So the people who plan in advance, I love them. They come in and they say, you know what, I don't want to do to my children what my parents did to me. It was really hard when my parents passed away or when they were in the final stages of life. I want to make it easy for my children. That's what I hear a lot, and that's what I'm very happy to hear. So whether it's an easy process or a difficult process, that's up to you, and that's why I'm so glad that you're here today. So as far as healthcare decisions, let's start with that. We know that we have incredible medical science these days, and we know that people are simply living longer. That doesn't mean living healthier by any means. We have some very, very sick people who do not have a very good quality of life, but they're still with us. Dementia and Alzheimer's is an epidemic. So we need to really consider what our options are. Now, it's important to know that years ago, we didn't have options. The law basically was not on our side. But since the early 70s, there's been a lot of people who've come before us, and they fought their way through the court system. And they've made the court system and also the legislators recognize our rights. And so we have to kind of jump through the hoops that they've set out for us to make our voice heard. So it's important that you know what those hoops are. So the people that came before us that fought through the court system, it took years and years. So here we're sitting in 2016. We need to take advantage of what those people before us have done for us, which we are very grateful and thankful for them. So now we have these end-of-life rights that we simply didn't have before. So let's do a real brief history to kind of let you know where we've come from. The first one was in 1975. So prior to that, we didn't have anything. It was really up to the doctors and up to the hospitals. But you might remember the famous case of Karen and Quinlan. And she was in a persistent vegetative state. She had a respirator. And her father, Joseph, fought very hard through the court system to have that respirator removed. That was considered a right to refuse treatment case, not a right to die case. So as far as right to refuse treatment, the court ultimately found, after years of fighting, that Karen had a constitutional right to privacy and that she was allowed to refuse medical treatment. So the respirator was removed, and ultimately she lived, I believe, another 9 years without the respirator. So the big key was she had the right to refuse treatment. Your wishes control rather than the doctor's wishes. Now, since 1975, every state and every legislature has passed all kinds of laws, and there's been all kinds of fighting and new court cases, and it seems to get more and more complicated every year. But this was the first one, and we know now that we have a right to refuse treatment. Now, the next big case was actually a right to die case, and that was Nancy Cruzan, and she was in an auto accident. She was also in a persistent vegetative state, and her case was different because her parents fought to have the feeding tube removed. So that was a right to die case, because unlike Karen, who lived another 9 years, when they were going to remove Nancy's feeding tube, she was going to die. So this was very, very hard fought. And ultimately, the court said that we do have a constitutionally protected right to refuse life-prolonging treatment. That includes artificial hydration and nutrition. But the big deal here was, remember, Nancy was in a vegetative state. She couldn't voice what it was that she wanted. We didn't have the fancy healthcare directives and the power of attorneys for healthcare like we have now. So the court had to have clear and convincing proof that Nancy would not want to live that way. So there had to be hearings, and there had to be things like that. So what happened, what transpired is the court recognized that if we can prove what we want, the courts and the doctors, everybody has to follow what we want, but we have to make it clear. This clear and convincing evidence standard is really important. So how do we meet this? Well, under federal law now, so just about every state and also federal speaking, we can now name a proxy or an agent to make decisions for them. So we do that in a form of a legal document. This legal document is what we put down, what we state we want our wishes to be. And we name our proxy or our agent to carry out those wishes, to talk to the doctors, to make sure our voice is heard. So this document is called different things in different states, and it gets kind of confusing. For example, in many states, including California, it's called an Advanced Healthcare Directive. In other states, or in the old days of California, it was called a Power of Attorney for Healthcare. Now, this is kind of confusing because there's also a power of attorney for financial management. So lots of people just say, well, I have a power of attorney. That's not good enough. Well, is it a power of attorney for healthcare, or is it a power of attorney for financial management? So in this case right now, we're talking about healthcare. So see if your state recognizes the healthcare directive or the power of attorney for healthcare. A rose is a rose by any other name, but it is different names. Some states, they reference living wills. So whatever your state calls it, it is a legal form, And you have to fill it out, you have to say what you want, and you have to appoint your proxy or your agent. So let's talk about this healthcare document. Whatever you want to call it, it's important. You have to be an adult. So if you have a son or a daughter or a friend or a parent or something like that, and they're over the age of 18, they need one. Once you're 18, you have to have a healthcare directive. You have to meet that clear and convincing evidence standard that this is the treatment that you would want. You must also be of sound mind. So I have lots of people coming to my office saying, well, Dad has advanced Alzheimer's, but we need a healthcare document. Once Dad loses capacity, he cannot sign anymore. So strokes, things like that, you have to sign these things and know what you're signing before you lose capacity. So the earlier, the better. And in this document, what do you get to choose? Well, you choose when it takes effect. So my favorite, but it's up to everybody else, is it's good, we say it's good immediately. It's good right away. So for example, I am trying to deal with a situation now where a client has a healthcare directive, but it's good only when a doctor says that he's lost capacity. Well, he's on a ventilator, and I can't get a doctor to say he's lost capacity. He clearly does not have capacity. He can't communicate. He doesn't know what we're talking about. But to get that doctor to say he's lost capacity, can't seem to get that. It's taken us weeks so far. So everything is slowed down, and that agent can't make decisions. That document is not valid until he's declared incapacitated. So my preference, but this is completely your decision, is to make it immediate. So when my mom was doing her healthcare directive, she considered this carefully, and she made me her agent effective immediately. And what that meant was I did not need a doctor to declare her incapacitated. So every time she went to the doctor would always look at her, nose to nose. What is it that you want? When she was in the hospital, what is it that you want? They would always communicate with her first. But boy, oh boy, when she went into hospital in the ER because we thought she had a stroke, and I had to kind of call the shots, I didn't have to wait for a doctor to say she was incapacitated. I was able to take control of the situation. So in my personal family situation, the immediate power of attorney or healthcare directive, that was invaluable. What you choose to do, that's up to you. You also choose who your agent, your proxy decision maker is. Now this is important. This isn't, well, Johnny is the oldest, so therefore, no, no, no. This is who do you trust to carry out what you want to be done. And this is important because I have doctors talking to me and saying, well, Mrs. Smith said XYZ in her healthcare directive, but Johnny is saying, no, 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 this is what we're going to do for mommy. Well, which is it? Well, in most states, the agent or the proxy gets to basically stand in your shoes. So if you said, I don't want a feeding tube no matter what, but the doctor says to Johnny, it's probably a feeding tube is until she learns to swallow again. It's only a few days. Johnny can actually say, okay, let's do the feeding tube. He can insert his judgment because you've given him that power. So you need to go through your healthcare directive because in that situation, that's a good thing. But you want to see how much power you're giving to Johnny and make sure that Johnny is going to be somebody that you trust to make these important decisions. You're also going to choose your healthcare and your end-of-life preferences. So how do you feel about end-of-life issues? How do you feel about ventilators? Do you want to be hooked up to machines? What if you have complete dementia, Alzheimer's, your brain is mush, they want to do kidney dialysis, they want to keep you alive that way? How do you feel about pain medication? What if you're suffering? Do you want more pain medication? What if it makes you die a little bit faster because it might slow down your heart rate? How do you feel about all these things? Burial, cremation, all that stuff needs to be in your healthcare document. So these are important decisions. So where do you get this really important document? There's lots of places. If you have an estate plan, your attorney very likely did one. There's usually like a package. The attorney will usually do a will, a trust, a power of attorney for financial management, a healthcare directive, or a power of attorney in your estate for healthcare, whatever they call it in your estate. But often an attorney handles that document. What if you don't have an estate plan? Or what if your healthcare directive is very old and it's time to update it? You've changed your mind. Well, the internet has lots of free forms. Just make sure it's appropriate for your state. Okay? It doesn't mean that it wouldn't be valid in other states, but every state has its own rules and regulations, so you want to make sure that it's state specific for you. Hospitals often have generic forms. There's one that's used quite a bit. It's good in 42 states, $5, can't beat that. It's called the 5 Wishes. So you can go online and you can download that and fill that out. And typically it's 2 unrelated witnesses to you who can sign it, or a notary. But again, check your state-specific qualifications there. But the thing we have to make sure of, my big deal here as a lawyer, is remember about HIPAA, Health Insurance Portability and Authorization Act. So you might remember this. A few years ago, Congress passed these laws because they wanted to protect medical information. They wanted to safeguard our privacy. So in the old days, you'd go to the doctor and they'd say, "Mr. Smith, would you come up and talk about your prostate exam?" You know, and these days, ooh, it's big lockdown. You know, you can't hear about anybody's information. You can't even see who checked into the doctor's office before you, because everything has those white strips on the sign-in sheet. So it's very, very private. Well, HIPAA allows you, if somebody signs a HIPAA release, to get that information about you. So, for example, my mom's HealthCare Directive has a HIPAA release in it. Very important. So when she was in the hospital for that suspected stroke, and I went to the nurse's station and I said, I want to see what you know, the doctor came at 2 o'clock in the morning, I hear. I want to see what medications they're giving her. I want to see what's going on. Let me see the chart. Oh, can't. Lockdown of private information. HIPAA, we can't give it to you. Oh, I have a HIPAA release. It's in the HealthCare Directive. Oh, okay, here you go. It's legal now. Here you can see. And so I was able to look at that information where I would have been blocked without it. So many times when you get the 5 Wishes or you get a generic form, it may not have a HIPAA release in it. I feel that's very, very important as a lawyer. So take a look at yours. If you have one, make sure it's got these HIPAA releases in it. Or if you get one off the internet or from the hospital, make sure it's got a HIPAA release also. Another really important form that may or may not apply to you is called a POLST. This is what it looks like. It's a physician's order for life-sustaining treatment. And this is there's about 35 states that recognize this. So it's kind of relatively new for California, but it's been around for a while. What this is this is a complement to a healthcare directive or power of attorney for healthcare. So this is really for people who are in the final year of life. They're very elderly. It's basically the equivalent of, or it's the new take on a do not resuscitate order. So when you have a healthcare directive or a power of attorney for healthcare, it names your proxy, your agent. It says what it is that your wishes are. But it's not a doctor's order. You know, the paramedics will still come, they'll still give you CPR, they'll still try and restart your heart, they'll transport you to the hospital, and your agent will call the shots if you can't. A POLST is different. This is a doctor's order. It says, don't even start that heart. Let them go. Why would we do CPR on a 96-year-old lady that was going to break all their ribs and cause more complications? But it is something that has to be signed by the doctor. And in some states, a nurse practitioner, a physician's assistant can sign it, but that's state specific. But it's an order from the doctor. You get it from the doctor or you can download it. It's on brightly colored paper. So the idea is when the doctor walks in the hospital room or comes into the room to examine you, he's going to go right to that pink form. He's going to see that pink form and know, oh, this is a POLST. Okay. And wherever your thick medical records go, they're always going to see that bright pink form and be able to go right to it. But again, it's not good for everybody. When I took my mom to the doctor and she's 80 years old and she has pretty advanced dementia now, doctor said, hey, it's time for a POLST. It's like, yeah, you're right. Hate to say it, but it's not mandatory. You know, it doesn't name who your agent is, like the healthcare directive. So they're both very important documents. If you're younger and you're healthy, you're not going to need a POLST. They won't give it to you, but you need a healthcare directive. If you're elderly or you're very sick, you'll want this. You very likely want this doctor's order. Again, it's complementary to the healthcare directive, and it has to be signed. So if you download it from the internet and you fill it out, it still isn't good. That doctor has to sign it too, or the medical professional. And it is supposed to create a dialogue between the medical professional and the family about end-of-life decisions. Doesn't cover them all, but it covers some really important ones like feeding tubes and things like that. Now, a lot of states, well, not a lot, I guess there's 5 in the US and then one that is by court decision, are now allowing physician-assisted suicide. So you might remember that Oregon was, I believe, the first state. And this was a big deal because, for example, my mother-in-law passed away last year of cancer. And it was not an easy go for her. And she wanted to move to Oregon to have the right to die. And California recently passed, too late for her, but passed as of January 1st this year, a physician-assisted suicide law. We can't really call it physician-assisted suicide because we have to call it end-of-life options. The physician can administer a lethal dose of medication, and the person has to be able to ingest that themselves. So these states have that type of law, but it's important to know whether or not your state allows that and what the qualifications are. In California, we have to have several requests, 2 verbally, 1 in writing. There's lots of, again, hoops that you have to jump through, so it's not easy, but every state's a little bit different. So that's something that you should keep in mind, whether or not that would benefit you. So we've talked about the HealthCare issues. So again, really important, anybody who's over 18 really needs to get that power of attorney for HealthCare / HealthCare Directive. Make sure there's a HIPAA release in there. So let's go to the next checklist item, the power of attorney for financial management. So this is a very important thing. You need to, again, appoint an agent, someone who can speak for you, who can deal with insurance companies and financial institutions. If you get sued, basically can do whatever you can do from a businessy standpoint. Credit cards is a big deal. When my mom was getting dementia 1 month, I found that she charged $14,500 on her American Express card through Home Shopping Network. It was terrible. Boxes all over the living room, opened up everything, nothing was returnable, parts missing, $14,500 bill. They wouldn't talk to me. American Express and Home Shopping Network legally could not talk to me unless I had this power of attorney, which I had. And again, is this power of attorney immediate, or does a doctor or 2 doctors need to say that she's incapacitated? Luckily, my mother's was immediate, so I could then clean up the mess that we were dealing with. I've used her power of attorney now that she has Alzheimer's disease. I can't tell you how many times, just tons of times. If I didn't have it, nobody would talk to me, and I would have to go to court and get a court order, get a conservatorship in the state of California to be able to be the spokesperson for my mom. But remember, the power of attorney for financial management is completely separate than the HealthCare documents. Okay. So the important thing to remember about power of attorney for financial management is most states have laws that say we're only going to allow you this many powers unless you say what the additional powers are. So for example, in California, and it's probably the same in your state, we can't gift money, we can't rearrange assets or restructure assets for public benefits or for Medicaid or things like that unless it says that you can do that in that power of attorney document. So a lot of people in my office and they say, I have this 2-page power of attorney that I got off the internet, but nobody's taking it. And I say, yeah, because ours that we do in our office are about 24 pages single spaced because we have all the powers that the agent can do. That little 2-pager, it doesn't have a whole lot of powers in it. So just keep that in mind. Take a look at yours. See how old it is. Because old ones, again, it doesn't deal with important issues. These days we live in an age of digital assets and passwords and all kinds of things. Your power of attorney for financial management should address all those very important modern issues. The next thing that we need to talk about, so we talked about healthcare, we've talked about financial management, and now we're going to talk about asset transfer plan. So this is what happens if you're very ill, you pass away, how are things going to get to who you want them to get to? So it doesn't happen automatically like a lot of people think. So let's talk about that. The first option that you have is something called joint tenancy. So this is like you have a bank account and you and your spouse are on the bank account and your spouse dies, you're a co-owner, everything goes to you. Great. Or your mom is elderly and you're on the bank account with your mom, Your mom dies, automatically it's yours because you're on it as a joint owner. The danger of that is if you get into a car accident, you have a bankruptcy, you have a lawsuit, you're an owner just like your parent, whoever the joint owners are. So it might cause some concern. There might be some issues there. But joint tenancy, remember, it just passes to the joint owner. Not great in all cases because let's say mom has 5 kids and she puts you on as a joint owner on her account, and then she dies and it all passes to you. Great for you, not so great for your siblings, and they're going to say, hey, that's not what mom wanted. You shouldn't have gotten all that money. And then what are you going to do? Are you going to keep it all? Are they going to sue you? Are you going to give them their share, so to speak? Well, legally you don't have to, but if you do, what about gift taxes? It's no longer an inheritance, it's a gift. So be careful with the joint tenancy. The other way to transfer assets is by way of beneficiaries. So I can't tell you how many times we see life insurance, annuities, IRAs, and there's no beneficiary designation on it. Everything that has a designation, you should have a beneficiary designation, and keep these up to date. People come in and they have their old life insurance and it names their parent who died 30 years ago because they got this policy when they were 18. Make sure that you have an up-to-date beneficiary designation. Don't name your former spouse if you're divorced and you don't want that spouse to get that IRA. Make sure it's up to date. So the things that you can put beneficiary designations on are life insurance, annuities, IRAs, bank accounts. Things that you can't are typically brokerage accounts, houses, things like that. Another possibility is a revocable trust. Now, these have a great value in California, maybe not so much in your state, because in California, our probate process is really hard. It takes an absolute minimum of 9 months, but never only 9 months. It takes a lot longer than that, and it's very expensive, and our courts are very, very crowded. So a good way to avoid the probate court is a revocable trust. But a lot of people I talk with, there are a lot of lawyers in other states, they go, oh, our probate procedures, oh, so easy. Within a couple of weeks, we're done. So it really depends on your state. It's good to get some legal advice. It's worth the investment to find out what's right for your state. Most states, I would say, a revocable trust is still a good idea. So the revocable trust is a contract, basically. You write up the contract with hopefully the help of a lawyer. Online services really don't know you. They don't know your situation. I see a lot of problems because you might have some hot button issues, like you might have an heir who is disabled. Maybe that heir is receiving Medicaid, Medi-Cal, SSI. Maybe they need a trust themselves, like an inheritance trust, because they can't hold on to money very well. Maybe they're under the age of 18. Maybe you don't want to give an 18-year-old all this money because they'll go blow it on a Maserati. So the revocable trust is your way to control from the grave. It's a contract. And you name somebody who's the trustee to make sure your wishes are carried out. So rather than a judge in the probate court, you've named this person, this trustee. Again, the name trust, you have to trust them. So the revocable trust is a way to avoid the court system and control from the grave. So they're very popular, especially in California. A lot of people who do nothing at all, their stuff has to go through the probate court, and there's no option. So I handled a matter years ago, and I'll never forget it. The gentleman committed suicide, and it was terrible for his only daughter. She had to clean up the blood, and oh, it's just poor thing, the worst case scenario. He had like 4 houses, 4 rental properties, and they were all in his trust. So very quickly and very easily, we were able to transfer out those rental properties by way of deed to her. Need the death certificate, do some deeds, out they go. Now she has it. No probate court, no inheritance taxes, very easy. But he had an account in a bank, and it was over the threshold amount. The threshold amount in California is $150,000. It's different from your state, I'm sure. But since it was over that threshold amount, the bank says, we're not giving it to you because it's in his name alone. It says John Smith. The daughter wasn't on the account. There was no beneficiary designation. It was not in a trust. So the bank said, we need a court order. Go through the probate court. So she had to go through the probate court. It took over a year. It took a ton of money to finally get that asset to be released to get to her. Was the bank wrong? No, that's the law. okay? The man didn't say what his asset transfer plan was for that big bank account. A will, lots of older people think a will is all they need. At least in California, a will is just a letter to the judge at the probate court. So when that gal I told you about had to go to court because of that one big asset in the bank that wouldn't be released, her dad did a will, and that will said, hey, judge, if we're in the probate court, look, it says right here, pour it into my trust. So the judge said, okay, that big bank account, it goes into the trust. The trust then says it goes to the daughter, but it still took over a year to do that. So wills, only good if you're dead, and it's just a letter to the judge at the probate court. Okay, it doesn't help you if you're sick, if you're incapacitated, things like that. I meant to put irrevocable living trust here instead of revocable, so I'm sorry I've got revocable in 2 places. Irrevocable living trusts, be real careful about that. They're only good in a sliver of situations, usually when we're planning for public benefits, because an irrevocable trust means you've given that money away. It's not yours anymore. We typically want revocable trusts where if you change your mind, you can change what you want, you can revoke it, amend it, it's completely up to you. Irrevocable trusts are completely different, and once you do it, it's done. Another option, which I don't like, is do nothing at all. This is what causes the family to have a lot of problems afterwards. So I don't recommend this option, but it happens a lot more than we would like to think. So those are your asset transfer options. So we've covered healthcare, we've covered finances, okay, if you're incapacitated or ill, and we've talked about asset transfer. So let's talk about this important checklist. Let's sum it up. The first part, healthcare decisions. Remember, name your agent. Not so much, oh, Johnny's the firstborn. No, it's who do you trust? I typically see mom and dad, and they're in their late 80s, and they're having a terrible time health-wise, and dad has dementia, and mom is using a walker, and she's on oxygen, and she can't talk on the phone because she's hard of hearing. She can't come up with those decisions. She can't process the information about dad. Why is she dad's agent? No, no, no. Look to see who the agents are. Can they handle emergencies? Can they process the information about healthcare fast? Do you trust them to carry out your wishes? Okay. Also, remember, HIPAA releases are very important. Make sure that's in your healthcare directive or a standalone document. Is a POLST appropriate? If you are not very elderly and if you're in decent health, probably not. Remember, a POLST is like a do not resuscitate order, but it even has more stuff. It is a doctor's order. And just keep in mind, as your state offer physician-assisted death options, you might be, unfortunately, or someone you love might be like my mother-in-law, where that was something that she wanted to pursue. My father died of cancer in 2001, and when he passed away, he said that he would have committed suicide had it not been for the stigma of that and having that be on the death certificate, because it was not an easy go. So nowadays you don't have to suffer like that. Depending, this is a hotly debated issue, but we do have some states that allow that. As far as financial decisions and management, your power of attorney for finances, remember, name your agents. You have to trust them because they're going to be having a lot of control over your assets. What powers are you going to include, and make sure you understand those powers? And do you want powers in there that have to do with public benefit planning? I have when I talk to people, I say, okay, what happens if you have a brain aneurysm? What happens if you're in skilled nursing and insurance runs out? And now, because you have this critical type of care, it's now $700 a day. Now, you will go bankrupt, and we need to do Medi-Cal planning. Do you want your next of kin, your trusted agent, to be able to make some planning decisions for you? Yes or no? Okay, that is your call, and that can be in your power of attorney for financial management. Think about number 3. What's your asset transfer plan? What's best for you? Joint tenancy? Beneficiary, nothing, a living trust? Think this through. If you're not a lawyer, it might be worth a complimentary consultation somewhere with somebody who really knows something about this area, because everybody's different. a trust is not necessarily the right thing for everybody. Some people do just fine with, beneficiary designations, but some people have very complicated estate plans. I can't tell you how many times people come in and say, oh, it's easy, my thing, it's just so easy. And then I find out, well, there's a black sheep son that's going to sue everybody when mommy dies. And then we have a disabled daughter, and then it gets crazy. So we really need to get the proper legal advice when you figure out what your asset transfer plan is, unless it's very simple, unless really truly you have a bank account, and that's it. Then you can leave it by beneficiary designation. What's the probate process like in your estate? Are you like California, where it's a big deal and you really should avoid it if you can? Or is it really simple? And there are some times where you want the probate process. Like I've had clients who have very messy estates. They have lots of business holdings and decisions to make, and they don't trust anybody to do that. They want the court involved. Most people aren't like that. They don't want the court involved. They want their voice to be heard. But that's up to you, your decision. But again, it's important for you to make these decisions. So consider your checklist, healthcare decisions, financial decisions, and asset transfer plan. I promised the ladies in my office that I'd put up a slide of all of us there. That's my office staff. We're in Valencia, California, and this is the area of law that we practice. And I certainly hope that this was helpful to you and that it was causing some food for thought. So with that, I believe that we're going to open it up to questions. Is that right?
Yes, thank you so much, Jane. That was really, really informative. We've got a bunch of questions already. I apologize if we can't get through all of them. If you do have a question for Jane, please type it on the chat box on the right-hand side of your screen. The first question is regarding handouts. So this presentation, you can get the PowerPoints. If you see there's a PDF on the right-hand side of your screen, you can download the checklist that Jane spoke about. So Jane, first question. Bunch of questions here, and they're pretty tough. So let's start from the beginning. So if a person is caring for an individual who is known with significant developmental delays, nonverbal, non-ambulatory, and does not have legal adult guardianship, what are the options for the family members?
Okay. Really the best option, they have to have capacity to sign these legal documents. So for someone who's developmentally disabled, many times, Down syndrome, there's a million different diagnoses, but if they legally or medically cannot sign these documents, they don't know what they're signing, they can't think these things through, the only other option is to go to the court. And that would be a guardianship in other states or a conservatorship in California and some states. So unfortunately, that person who's caring for that individual would need to get the court order to be able to make medical and financial decisions.
Great, thank you. My neighbor had no family and left their estate to the Jewish Children's Family Services, thinking their estate was in good hands. They live incapacitated, and their vacant home is now growing mushrooms because of vacancy and neglect for 10 years now. It is a fire hazard. Who is legally responsible for this estate? Okay, well, I tend to wonder if that beneficiary, that charity, knew that they got this. I wonder if anybody actually administered that estate. It is possible that that elderly couple or whoever it was, they died and the asset wasn't actually transferred. So the first thing I would do is, there's public records to, you can look up the address and see what is title. Is it this charity? And if they have taken title of it, then they have to handle that. They can't let it rot away. They can't have a fire hazard. They can't have vagrants come. They have a legal responsibility to take care or to do something with that home. But my gut feeling is, if you looked at title, that is a public record, you could probably get a copy of the deed from a title company. You'd probably find that that home is still in the deceased person's name. Great, thank you, Jane. And then I would say that beneficiary needs to know so they can start the right proceedings to get that asset transferred. Great, thank you, Jane. If accounts were held in joint tenancy, but the will states all assets be split between surviving kids. Does the will supersede the joint tenancy?
Nope, the joint tenancy controls. So be real careful here. So many times when I deal with elderly people, and they have $200,000 in the bank and they've named Susie on that account, it's like, whoa, 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 wait a minute. No, I know your will says or your trust, but this is a joint account. This will legally pass to Susie. Is this what you want? So that's a big problem. So yes, the legal title of that bank account controls.
Great, thank you, Jane. If you have a living revocable trust, do you also need documentation referencing a last will and testament, or is the living revocable trust sufficient?
Great question. When we do living trusts, we always have a backup document. That backup document is called a pour-over will. So we never do a trust without that backup document. So the trust says all the assets that are connected to my trust, like my house, because the deed says trustee of the trust, so I know it's connected. My bank account says trustee of the trust, I know it's connected. My trust handles those assets. But oops, guess what? I'm like that man who committed suicide. I forgot to include my Bank of America account. It's not part of my trust. It just says my name. I die. And just like that example I gave you, now that has to go to the probate court. And the judge at the probate court says, okay, where's my will? I want the letter that tells me what you want to be done with it. Oh, here's the will. And it says, oh, he has a trust. Put it into the trust. Pour it into the trust. Pour over a will. So the will is a backup just in case you need it.
Great. Thank you, Jane. Is a proxy able to make amendments to negate a POLST?
Yes. Yes. The answer is you are naming somebody, and that's why you have to trust the person who you name as your agent. You have to really know. We can't predict every medical outcome or every technology. You know, I remember when my dad was on hospice, they said, oh, guess what? Yesterday this new chemotherapy treatment was approved. Let's take him off hospice and let's try this. Who would have thought? Now, all these years later, we have so many more treatments that we didn't have back then. So we have to really trust our agent to be able to say, well, when they signed this or when they said this, yeah, that's what they wanted, but they didn't know about this issue. And so we have to trust them to be able to do what they believe we would want to be done. So the answer to that is yes.
Great. There's so many questions here. I apologize that we're not going to be able to get through all of them. I think we have time for a couple more. What happens if you have an estate in one state and then move to another state? Are the documents still valid or should they be redone? Do these documents expire? If so, should they be renewed and signed annually?
I love these questions. These are great. Okay, it depends on the state. The United States has something called the Full Faith and Credit Act. And what that means is if you move to a different state, they're supposed to honor the other state's documents. But it gets a little bit more tricky than that because some states honor POLST, some states do not. So if you become a resident in another state, and by a resident, I mean you're there for like 6 months, I would say time to redo your HealthCare directive and your power of attorney for finances. If you have a trust, take a look at the trust. A lot of trust says this trust is only good in the state that it was written in. So you're in California, you move to Montana, you know what, make sure that you have you'll have to go back to California. Somebody's going to have to apply California laws. Maybe Montana laws are better. I like to do trusts that say, hey, it's good wherever you go, just apply those laws. Your trustees can make this a Montana trust then. But a lot of lawyers don't do that. They don't think to do that, or it's not the right thing to do under those circumstances. So it really depends on your documents. As far as expiration, check it. Most modern documents do not have an expiration. Some of the older documents do have an expiration, so you just have to look at it. But things change in people's families from year to year. So I always say, when you're doing your taxes every year, just think about your documents. Has anything changed? Have you gotten into a fight with your best friend who was named as your power of attorney, your agent? If so, get that thing changed. Just think about it at tax time. Doesn't mean you have to make a change, but bring it to the forefront.
Great. Thank you, Jane. My mother has lived with me for over 5 years and is now unable to make decisions. Do I have any rights with my mother's care when my siblings disagree? Can my siblings take my mother out of my home without permission?
Oh, that's a good question. Classic case of can they take her, if there's a battle, somebody's going to have to go to get the court backing. We call these contested conservatorships, and they're very common in this type of thing. So you have a sibling who's really not involved saying, well, you're taking all mom's money, or you're not providing her the best care, or whatever it might be. Can they go to court and have this person removed? Yeah, they sure can, but it depends on the court. So when we have that kind of situation, most of the time the courts get involved. And that's why it's so important to have, before somebody loses capacity, have that person write, this is the person I trust, call the shots, what they say goes. That would have been very helpful in this position, or in this situation, because now all siblings are pretty much equal.
Great. Thank you, Jane. Thank you so much for this great presentation, the great Q&A. There were so many great questions out there, and I apologize that we're unable to answer all of them. Thank you, everybody, for attending this great webinar. Jane, thank you for this really, really informative presentation. The handouts, again, you can download those on the right-hand side of your screen. They're in PDF form. They're all the PowerPoints that you saw today. Again, if you missed any portion of this webinar, this will be recorded and posted on our Shield HealthCare site. That's www.shieldhealthcare.com/community. Again, thank you so much, Jane. Thank you to the attendees. Any last words before we part?
I love those questions. It sounds like it got a lot of people thinking, which was the goal. So thanks so much for having me. This was a lot of fun.
Great. Thank you again. Have a great rest of your day, everybody.